Three political parties are seeking urgent relief of the Apex Court after they failed to comply with the March 8th deadline to submit candidate lists in accordance with Section 27 of the Electoral Act. Canny Maphanga, SABC News Senior Reporter, has been following proceedings and joins us live now with the very latest. Good afternoon, Canny. An interesting day in court. So before we get to the arguments put forward by some of the political parties, can you firstly just share a bit of background on this case, which was before the Electoral Court not so long ago?
Well, good afternoon to you, Mfundo, and to the viewers at home. Well, judgment has been reserved in the court application that was heard this morning by three political parties, that is the Labour Party, the ACT Party, and the African Alliance of Social Democrats, who are essentially trying to rejoin the race to the May 2024 polls by approaching the ConCourt. Now, this all stems from the 8th of March submission deadline. You may remember there were a number of parties, particularly unrepresented parties, and this could be attributed to the fact that this really was a lot of new requirements that were needed in order to contest the national and provincial elections. Now, some of those parties were not able to meet that Section 27 of the Electoral Act requirements in the submission deadline, and because of that, they were barred from contesting the national and the provincial elections. Now, a lot of those political parties are blaming that online portal of the IEC, stating that, or alleging rather, that it malfunctioned as they were trying to submit those lists in the final hour, and that they're asking the court to now grant them an exemption of sorts by allowing them to at least meet that Section 27 requirement so that they are able to contest those national and provincial elections.
Now, if we had to be a little more granular and just look at those arguments, AMCU's Labour Party was the first to take the stand, stating, among others, that their exclusion in this year's election contest is not due to tardiness or ineptitude on their part, but due to, as you say, the malfunctioning of the IEC's online portal. Just talk us through some of these arguments.
Well, if we look into the background, this is not a new case or new facts that are being brought before the Apex Court. You may remember this was in the Electoral Court, and the Electoral Court found that they had failed to substantiate this claim that the system was not functioning at the relevant times when they were trying to upload those submissions in order to meet that Section 27 requirement. Now, you may remember the Labour Party earlier today, they've approached the court on direct access. So they've left this issue of an appeal and approached the court on direct access, saying that if you look at the report of the system, they've argued that there was a 35% failure rate, and on that basis alone, it shows that the system was not functioning, not the parties themselves, and arguing that the parties should be given a chance to just at least meet that requirement so that you don't only prejudice those political parties, but some of those voters and those who have shown support in the form of signatures, so they have a right to vote for who they want to vote for when we approach the May 2024 polls.
Then to the implications of the relief sought on the elections. We are 21 days away from election day. What could the implication be if the orders are granted in their favor, these three political parties?
Indeed, Fundo. Well, the implications are quite significant, especially for the May 2024 polls. The election timetables by the IEC rather exist for a reason, Fundo. That is so that we can get to those 29 May polls, and everyone should follow those rules that adhere to what the IEC has set and gazetted in those timetables. Now, what essentially, if you do, is if you grant this relief, or if the ConCourt rather grants this relief, it means that there is exemption to political parties or particular political parties, which would not be fair, as some other parties may argue that they might want to use this opportunity as well to further meet that Section 27 requirement. And then, of course, you start the process of the election timetable, or you bring it back and you require an amendment, because once you do that submission deadline again, then you have to open it up for appeals, objections, and all the court matters that would follow after that. And then undoubtedly that would delay significantly the election date. You would have to request a new election date, which could be quite a costly exercise for the IEC. So the implications are quite significant, especially based on the remedy that these three political parties are seeking, which I see why the ConCourt bench was really struggling with granting this relief to these three political parties, when an overwhelming majority, including unrepresented political parties, were able to meet the Section 27 requirements. Now, we know that that judgment is reserved, but we do expect the ConCourt to pronounce on this matter prior to the election date of 29 May, even prior to that, because we know that voters abroad will have to start that process a bit earlier than us. So we can expect very soon, possibly, an order from the Constitutional Court taking this matter forward.